The loader's engine roared to life at 6 in the morning, and I knew before the day was over, someone would complain about the noise. What I did not expect was Patricia Henderson marching across her perfectly manicured lawn in her bathrobe and curlers, cell phone pressed to her ear, screaming about trespassing while my equipment operator carefully maneuvered the massive machine across the narrow strip of land that connected my property to the main road. I am Stephen Jenkins, and I have owned this 10-acre property in Riverside, California for 3 years now. The land came with a house, a barn, and most importantly, a legal easement that ran directly through what is now Patricia Henderson's front yard. The easement existed long before the Meadowbrook Hills HOA was established, long before Patricia bought her house, and certainly long before she appointed herself the neighborhood's moral guardian. The construction project had been months in the planning. I was finally building the workshop I had always wanted, a place where I could restore classic cars and maybe turn my hobby into a small business. The permits were approved, the contractors were hired, and everything was moving along smoothly until this particular Tuesday morning when the loader needed to transport materials from the main road to my property. My property sat at the back of the development, accessible only through the easement. When the original landowner sold off parcels for the housing development 15 years ago, he retained this strip of land specifically to maintain access to the rear property. The easement was recorded, legal, and irrevocable. I had done my homework, consulted with a real estate attorney, and had all the documentation sitting in a thick folder in my office. Patricia did not care about any of that. "You cannot just drive that monstrosity across my lawn," she shrieked, her voice carrying over the engine noise. "This is private property. I am calling the police right now." Miguel, my equipment operator, glanced at me uncertainly from the cab of the loader. I held up a hand, signaling him to wait, and walked over to where Patricia stood at the edge of the easement, her face red with fury. "Good morning, Patricia," I said, keeping my voice level and polite. "As I mentioned in the notice I sent to the HOA last month, I have a legal easement that runs through this section. The loader is staying within the boundaries of the easement." "I received no such notice," she snapped, though her eyes flickered slightly, suggesting otherwise. "And I am the HOA president, so I would know if such an easement existed. You are trespassing, and I demand you remove this equipment immediately." I pulled out my phone and opened the Photos app, scrolling to the survey map that clearly showed the easement boundaries marked with bright pink flags. I had the property surveyed 2 weeks ago. Those flags mark the exact boundaries. The easement is 20 feet wide and runs from the main road to my property line. Everything is documented and legal. Patricia barely glanced at my phone. "Those flags are on my property, which means you put them there without permission. That is vandalism. The police are on their way, and I expect you to be arrested for trespassing and destruction of property." I took a deep breath, reminding myself that losing my temper would only make things worse. "Patricia, I really do not want this to escalate. I have all the legal documentation. The easement is recorded with the county. Your property deed should have mentioned it when you bought the house." "My deed says nothing about any easement," she insisted, crossing her arms. "And even if it did, that does not give you the right to tear up my lawn with heavy equipment. The loader has tracks designed to minimize ground disturbance, and it is staying entirely within the easement boundaries," I explained. "I am not touching your lawn." A police cruiser pulled up to the curb, lights flashing but no siren. Officer Davis stepped out, a middle-aged man I recognized from the local coffee shop. He looked tired, as if he already knew this was going to be a long morning. "Someone called about a trespassing complaint," he asked, looking between Patricia and me. Patricia immediately launched into a dramatic retelling of the situation, complete with wild gestures and accusations that I was deliberately trying to destroy her property value. She made it sound like I had driven a tank through her rose garden out of pure spite. When she finally paused for breath, Officer Davis turned to me. "Do you want to tell me your side?" I handed him my folder, already open to the easement documentation. "I own the property at the back of this development. This is a legal easement that provides access to my land. It has been recorded with the county since 1995. I notified the HOA of my construction project and my need to use the easement. Everything is by the book." Officer Davis studied the documents carefully, then walked over to examine the pink flags marking the easement boundaries. He pulled out his own phone and spent several minutes comparing the survey map to the actual terrain. Patricia followed him, talking nonstop about property rights and HOA regulations. "Madam," Officer Davis finally said, holding up a hand to stop her mid-sentence, "this gentleman has a legal easement. The documentation is in order and the equipment is staying within the marked boundaries. There is no trespassing occurring here." "But my lawn," Patricia protested. "You can see the tracks." Officer Davis looked at the ground. The loader had not actually moved yet, so there were no tracks. "I do not see any damage, and even if there were tracks within the easement area, he would be within his rights to use it." "This is outrageous." Patricia's voice rose to a pitch that made several dogs in the neighborhood start barking. "I pay taxes on this property. That includes every square inch of my lawn. The easement is a legal right-of-way." Officer Davis explained with the patience of someone who had dealt with many HOA disputes. "It was established before you bought the property, and it does not matter whether you were aware of it or not. Mr. Jenkins has every right to use it." Patricia turned to glare at me. "The HOA will be hearing about this. We have rules about construction and property use. You cannot just do whatever you want." "I submitted all the proper notices," I reminded her. "I sent certified mail to the HOA board 6 weeks ago detailing the project timeline and the use of the easement. I have the delivery confirmations." "Well, I never received any such letter," she huffed. Officer Davis closed my folder and handed it back to me. "Everything appears to be in order here. I suggest you two work this out civilly, but from a legal standpoint, Mr. Jenkins is not doing anything wrong." He looked at Patricia. "Making false police reports can have consequences, madam. I would recommend you review your property deed and the county records before making any more complaints." Patricia's face went even redder, if that was possible. She opened and closed her mouth several times like a fish out of water, clearly searching for something to say that would make the officer side with her. Finding nothing, she spun on her heel and stomped back to her house, her bathrobe fluttering dramatically behind her. Officer Davis gave me a sympathetic look. "Good luck with your project and keep those documents handy. Something tells me this is not over." He was right about that. Miguel started up the loader again, and we proceeded with moving the materials. The machine stayed carefully within the easement boundaries, and despite Patricia watching from her window with binoculars, everything went smoothly. We made 3 trips that day, transporting lumber, steel beams, and bags of concrete mix. That evening, I found a notice taped to my front door. It was from the Meadowbrook Hills HOA, signed by Patricia Henderson in her capacity as president. The notice informed me that I was in violation of multiple HOA bylaws, including unauthorized construction, excessive noise before 8 in the morning, commercial vehicle use in a residential area, and failure to obtain proper HOA approval for modifications to my property. The notice demanded that I cease all construction immediately, and attend an emergency HOA board meeting scheduled for the following Thursday evening. Failure to comply would result in daily fines of $500 and potential legal action. I read the notice 3 times, feeling my blood pressure rise with each reading. Everything listed was either factually incorrect or did not apply to my situation. The construction was fully permitted by the county. The noise ordinance in Riverside allowed construction starting at 6 in the morning. The loader was not a commercial vehicle in the sense the bylaws meant, and my property modifications were entirely on my own land, behind the building line, and did not require HOA approval according to the CC and Articus I had reviewed extensively. The next morning, I called my attorney, Richard Morrison. He had handled my property purchase and was familiar with the easement situation. "They are testing you," Richard said after I read him the notice. "HOAs do this all the time. They issue violations hoping the homeowner will just give up rather than fight, but you have done everything correctly. Keep that notice, document everything, and definitely attend that meeting." "Should you come with me?" I asked. "Let us see how the meeting goes first. Sometimes having an attorney present right away makes them more defensive." "Go in, present your case calmly, and if they do not back down, then I will get involved officially." The days leading up to the meeting were tense. Patricia made a point of walking past my property twice a day, taking photographs with her phone. She even brought other HOA board members by to inspect the easement, standing just outside my property line and pointing at various things while shaking their heads. I continued working with my contractors, making sure every single aspect of the project was documented. I took photos, kept receipts, and maintained a detailed log of all activities. If Patricia wanted a paper trail, I would give her one. Thursday evening arrived, and I drove to the community center where the HOA held their meetings. The parking lot was surprisingly full. Apparently, word had spread about the dispute, and half the neighborhood had turned out to watch the show. Inside, the meeting room was set up with a long table at the front for the board members and rows of folding chairs facing them. Patricia sat in the center position, flanked by 4 other board members. I recognized 2 of them as neighbors I had waved to occasionally, but never really spoken with. Patricia called the meeting to order with a sharp bang of her gavel, which seemed excessive for a neighborhood HOA meeting. She ran through the usual business with remarkable efficiency, clearly eager to get to the main event. "We now come to the matter of Stephen Jenkins and his numerous violations of our community standards," Patricia announced, her voice taking on a formal, judicial tone that made it sound like I was on trial for murder rather than using a legal easement. She spent the next 10 minutes detailing every complaint she had compiled. According to her version of events, I was single-handedly destroying the neighborhood with my reckless disregard for rules and common courtesy. She showed photos of the loader on the easement, claiming they depicted the destruction of her property. She presented testimony from other residents about the noise, though I noticed most of the complaints came from people who lived nowhere near my property or the easement. When she finally finished, she looked at me with an expression of triumph. "Do you have anything to say for yourself?" I stood up, carrying my folder of documentation. "Yes, I do. May I approach?" Patricia looked like she wanted to refuse, but the board member to her right, a man named Thomas Chen, nodded. Let him present his side. I walked to the front and laid out my documents on the table where everyone could see them. First, the easement. This is a legal right-of-way recorded with Riverside County in 1995. It predates the HOA by 5 years and predates Patricia's ownership of her property by 8 years. The easement is irrevocable and grants me full access to my property via this route. I showed them the survey map, the county records, and the title insurance documents. When I purchased my property, this easement was clearly disclosed. When Patricia purchased her property, this easement should have been disclosed to her as well, as it is a recorded encumbrance on her deed. I was never told about any easement, Patricia interrupted. That is an issue between you and whoever sold you the house, I replied. It does not change the legal reality. The easement exists and I have the right to use it. I moved on to the next document. Second, the noise complaints. The Riverside Municipal Code allows construction activities beginning at 6 in the morning on weekdays. I have been starting work at 6, which is completely legal. Here is the relevant city ordinance. Thomas leaned forward to read the printout I had provided. He nodded slowly. This appears accurate. Third, the claim about commercial vehicles. The HOA bylaws restrict commercial vehicles from being parked overnight in residential areas. The loader was not parked overnight. It came in, did its work, and left the same day. That is not a violation. I pulled out another document. Fourth, regarding modifications to my property. According to the Meadowbrook Hills CC and Articus, Section 12, Paragraph 4, structures built behind the rear building line and not visible from the street do not require HOA architectural approval. My workshop is being built entirely behind the building line, as confirmed by the county permits and the survey. Here is a copy of the site plan. Patricia snatched the papers from the table, her eyes scanning them rapidly. I could see her searching desperately for some flaw, some mistake she could pounce on. The principle of the matter remains, she finally said. You are disrupting the peace and tranquility of our community. You are lowering property values with your industrial project. It is a workshop for car restoration, I corrected, and the county has zoned my property to allow for such use. This was verified before I purchased the land. Another board member, a woman named Susan Martinez, spoke up. Patricia, it seems like Mr. Jenkins has been quite thorough. I am not sure we have grounds to fine him if everything he is doing is legal. The HOA has the authority to enforce community standards, Patricia insisted. That is our entire purpose. If we let people do whatever they want just because it is technically legal, we might as well not exist. That is actually exactly how it is supposed to work, I said. HOAs can enforce their rules, but those rules cannot supersede county ordinances, state laws, or recorded easements. You can have standards for visible improvements, noise during restricted hours, and parking violations. But you cannot prevent me from using a legal easement or building a permitted structure on my own property. Thomas spoke up again. I think we need to table this matter and consult with the HOA attorney. This is getting into legal territory that we are not equipped to judge tonight. Patricia looked like she wanted to argue, but the other 3 board members were nodding in agreement. With obvious reluctance, she banged her gavel. Fine. This matter is tabled pending legal review. However, Mr. Jenkins, you are hereby notified that any further use of the disputed easement will be at your own risk. It is not a disputed easement, I said firmly. It is a legal recorded easement, and I will continue to use it as needed for my project. The meeting adjourned shortly after, and several neighbors approached me as I was packing up my documents. Most were supportive, sharing their own stories of Patricia's overreach. Apparently, I was not the first person to clash with her rigid interpretation of the HOA rules. She made me tear down a vegetable garden because she said it was not ornamental enough, one woman told me. I had to fight for 3 months and finally threaten a lawsuit before she backed down. She tried to fine me for painting my front door navy blue instead of the approved dark blue, a man added. We had to bring in paint samples to prove they were the same color. The stories went on, painting a picture of a woman who had turned HOA leadership into a personal fiefdom. I left the meeting feeling somewhat better about my position, but knowing this battle was far from over. 2 days later, Patricia made her next move. I was working in my garage on a Saturday morning when I heard shouting from the direction of the easement. I walked over to find Patricia standing next to the pink survey flags, a can of spray paint in her hand. She had painted red X's over several of the flags. "What are you doing?" I asked, genuinely baffled. "These flags are on my property," she said. "I am marking them for removal. I have also filed a complaint with the county about your fraudulent survey." The survey was conducted by a licensed surveyor using county records, I said, pulling out my phone to take photos of what she had done. "And you are now vandalizing survey markers, which is actually illegal in California." "I am protecting my property rights," she countered. Before I could respond, a silver sedan pulled up and a woman in her 30s stepped out, carrying a briefcase. "Mr. Jenkins, I am Elizabeth Morrison, Richard Morrison's daughter and associate. He asked me to stop by and check on the situation." I had not known Richard was sending anyone, but I was grateful for the timing. Elizabeth surveyed the scene, taking in Patricia with the spray paint can and the marked flags. "Are you the HOA president?" Elizabeth asked Patricia. "I am Patricia Henderson, and this is a private property matter that does not concern you." "I am Mr. Jenkins's attorney," Elizabeth said, her tone professional but firm. "And it does concern me if you are vandalizing legally placed survey markers. That is a misdemeanor under California Penal Code Section 605. I am documenting this incident." Patricia's confidence wavered slightly. "I have every right to mark items on my own property. The survey flags are marking an easement, which means they are legally protected markers. Altering or removing them is a crime," Elizabeth explained. She turned to me. "Have you contacted the surveyor?" "I am calling him now," I said, already pulling up the number. Patricia realized she was in over her head. She dropped the spray paint can and stormed off toward her house, shouting over her shoulder, "You will be hearing from my attorney." The surveyor, Bob Williams, arrived within the hour. He was not happy about the vandalized flags. "This happens more often than you would think," he said, shaking his head. "Property disputes bring out the worst in people. I will need to file a report with the county and document the damage. Then I will replace the flags." "What should I do about her?" I asked, gesturing toward Patricia's house. "That is up to you," Bob said. "You could file a police report. The county might pursue charges since these are official survey markers, or you could let it go and hope she gets the message." Elizabeth shook her head. "File the report. She needs to understand there are consequences for this behavior. Otherwise, she will just escalate." She was right, though I hated the idea of making things worse with a neighbor, but Patricia had crossed a line. I called Officer Davis and explained the situation. He came out, took my statement, examined the vandalized flags and wrote up a report. "I will talk to her," he said. "Hopefully, a warning will be enough, but if she keeps this up, she could face charges." Word of the incident spread quickly through the neighborhood. By Monday morning, my email inbox was full of messages from other residents. Some supported me, others criticized me for causing trouble. The neighborhood was becoming divided, and I hated being at the center of it. Patricia's attorney sent a letter that week. It was full of legal-sounding language, but ultimately said nothing of substance. They claimed the easement was invalid due to some vague irregularities, and demanded I cease using it immediately. Richard's response was swift and thorough, demolishing their arguments point by point and threatening a countersuit for harassment if they continued making frivolous claims. Meanwhile, my construction project moved forward. I needed to make several more trips with heavy equipment, and each time, Patricia made sure to be outside, filming everything with her phone. She was building a case, documenting what she believed were violations, but all she was really doing was creating evidence that I was staying within the legal boundaries. 3 weeks after the initial incident, the HOA attorney finally weighed in. The letter arrived certified mail, addressed to Patricia with copies to all board members. Richard had obtained a copy through his connections. The attorney's opinion was clear. I was within my rights to use the easement, the construction was legal, and the HOA had no grounds to fine or restrict me. The letter went further, warning Patricia that continued harassment could expose the HOA to liability. I thought that would be the end of it. I was wrong. The following Saturday, I woke up to find that someone had dumped a load of dirt across the easement during the night, completely blocking access. The pile was massive, at least 10 yards of soil, strategically placed to prevent any vehicle from passing through. I called the police immediately. Officer Davis arrived with another officer, and they took photos and measurements. There were tire tracks from the dump truck that had delivered the dirt, but they led only to the main road. "This is illegal obstruction of a right-of-way," Officer Davis said. "Do you have any idea who did this?" I glanced at Patricia's house. "I have suspicions, but no proof." As if on cue, Patricia emerged from her front door, coffee cup in hand, and walked over to admire the dirt pile. "What a mess," she said, her voice dripping with false sympathy. "Someone must have made a delivery mistake." "Did you see anything last night?" Officer Davis asked her. "I sleep very soundly," Patricia said. "I did not hear a thing." "This is your property line," the officer noted. "You are telling me a dump truck came in the middle of the night, dumped 10 yards of dirt, and you heard nothing?" "I already told you I sleep soundly," Patricia repeated. The officers exchanged glances. They knew she was lying, but without proof, there was nothing they could do. "I need this removed," I said. "I have contractors scheduled for Monday, and they need access." "You will have to hire someone to remove it," Officer Davis said. "We can document it as part of the incident report, but clearing it is a civil matter." I called a local landscaping company that did weekend work. They quoted me $1,500 to remove the dirt on short notice. I had no choice but to agree. While I waited for the landscaping crew, I reviewed my security camera footage. I had cameras covering my property, but they did not extend far enough to capture the easement. However, one camera had caught something interesting. Patricia's car leaving her driveway at 2 in the morning and returning an hour later. I sent the footage to Richard. "This is not proof she ordered the dirt," he said when I called him, "but it is suspicious timing." Combined with everything else, it helps establish a pattern of harassment. The landscaping crew arrived and spent 4 hours removing the dirt. I had them haul it to my property, figuring I could use it for landscaping later. At $1,500, I was not about to let it go to waste. Monday morning, I received another certified letter from the HOA. This time, it was not signed by Patricia alone, but by the entire board. The letter informed me that due to the ongoing disputes and disruptions to the community, the HOA was pursuing legal action to invalidate my easement claim. Richard laughed when I forwarded him the letter. "They are bluffing. No court is going to invalidate a recorded easement that has been in place for 30 years, but this is good news in a way. It means we can countersue for harassment, abuse of process, and maybe even malicious prosecution if they actually file anything. I just want to build my workshop," I said, frustrated. I do not want to be in court for the next year. Then we make this painful enough for them that they back down, Richard said. I am drafting a letter to the HOA board explaining their legal exposure. Sometimes all it takes is showing them how much this could cost them personally. Richard's letter was a masterpiece of legal intimidation. It outlined the strength of my case, cited multiple precedents, and detailed the potential damages I could claim if they continued their harassment campaign. Most importantly, it noted that HOA board members could be held personally liable if they knowingly pursued frivolous legal action. The letter had an effect. Susan Martinez resigned from the board the next week, citing personal reasons but privately telling me she did not want to be part of Patricia's vendetta. Thomas Chen started asking questions at board meetings about the legal costs and potential liability. But Patricia was undeterred. She called another emergency HOA meeting, this time focused on passing a new rule that would require advance approval for any vehicle over a certain weight to use neighborhood streets. The rule was clearly targeted at my construction equipment. I attended the meeting with Elizabeth this time. When Patricia presented the proposed rule, Elizabeth immediately raised her hand. This rule would be unenforceable against my client, she said. The easement grants him the right to reasonable access, which includes using appropriate vehicles for construction and property maintenance. You cannot pass rules that nullify recorded easements. This rule applies to the entire neighborhood, Patricia argued. It is not specific to Mr. Jenkins. The timing and the weight restrictions make it clear what this is about, Elizabeth countered. And even if it were neutral on its face, it cannot be applied in a way that restricts easement rights. I suggest you consult with your attorney before voting on this. Thomas spoke up. I agree. We have already been warned about our liability. Let us not make this worse. The vote failed 3-2. Patricia was furious, and her remaining ally, a man named Derek Foster who seemed to agree with her on everything, looked equally unhappy. After the meeting, Thomas approached me privately. Look, this has gotten out of hand. Most of us on the board just wanted to help maintain property values and organize neighborhood events. Patricia has turned this into her personal crusade. Is there any way to resolve this? I am open to reasonable discussion, I said, but I am not giving up my legal rights. The easement is not negotiable. I understand. What if we could work out some kind of accommodation, maybe limit the construction traffic to certain days or times, give advance notice for heavy equipment? I have been giving advance notice, I pointed out. Patricia ignores it. But I am willing to be more specific about scheduling if it helps keep the peace. We worked out a compromise where I would provide a weekly schedule of any heavy equipment use, and the HOA would distribute it to residents near the easement. It would not stop Patricia from complaining, but it gave the other board members cover to ignore her. The arrangement worked for about 2 weeks. Then Patricia escalated again. I came home from work one evening to find a construction fence erected across the easement. It was a professional installation, 8 feet tall with locked gates, completely blocking access. This time, I did not even bother calling Patricia. I went straight to the police and filed a formal complaint. Officer Davis came out and documented everything, including the company logo on the fence panels. I will contact the fence company, he said. They had to have a work order from someone. That will tell us who paid for this. The fence company was cooperative. They provided the work order, which had been paid for with Patricia Henderson's credit card. She had told them she needed to secure her property line due to trespassing issues. That is the evidence you need, Richard said when I called him. She is deliberately obstructing your legal right-of-way. We file for an emergency court order to remove the fence, and we add this to our damages claim. The emergency hearing was scheduled for 3 days later. Patricia showed up with her attorney, a nervous-looking young man who clearly had not expected to be in court on an easement dispute. The judge reviewed the evidence quickly. She looked at the survey maps, the recorded easement, the photos of the fence, and the work order. Then she looked at Patricia's attorney. "Counselor, what is your argument for why your client has the right to block a recorded easement?" The attorney shuffled his papers. "Your Honor, we believe there are questions about the validity of the easement that need to be resolved. In the meantime, our client has property rights she is entitled to protect." "The easement has been recorded for 30 years, the judge said. "Your client purchased her property with this encumbrance already in place. What specific defect in the easement are you claiming?" "We are still researching that, Your Honor." The judge was not impressed. "So you are blocking the easement based on research you have not yet completed?" "Mr. Jenkins has shown clear documentation of his rights. Unless you have evidence that the easement is invalid, your client cannot obstruct it." She ruled from the bench, ordering Patricia to remove the fence within 24 hours. She also ordered Patricia to pay for the emergency hearing costs and warned that any further obstruction would result in contempt charges. Patricia left the courthouse looking shaken. Her attorney was talking urgently in her ear, probably telling her she needed to cut her losses. The fence came down the next day. I thought maybe, finally, this would be over. Instead, Patricia went around the neighborhood collecting signatures on a petition. She was claiming I was a danger to the community, that my construction project was going to bring noise, traffic, and lower property values. She was calling for a special HOA vote to purchase my easement rights, effectively paying me to stop using it. The petition gained some traction. People who were tired of the conflict saw it as a compromise. What they did not realize was that I had no intention of selling my easement rights at any price. Without that access, my property value would drop significantly, and my plans for the workshop would be impossible. The special meeting was contentious. Patricia presented her petition with over 60 signatures. She had a proposal for the HOA to offer me $50,000 for the easement rights. I stood up when it was my turn to speak. I appreciate that people want to resolve this conflict. But what Patricia is proposing is not possible. First, I cannot sell easement rights I do not own. The easement is not my property to sell. It is a right that runs with my land. Second, the value of that access is far more than $50,000. Without it, my property becomes landlocked and nearly worthless. And third, this entire proposal is being made in bad faith. Patricia does not want to resolve this conflict. She wants to win it. I looked around the room at my neighbors. I moved to this community because I wanted a peaceful place to live and pursue my hobbies. I have followed every rule, obtained every permit, and done everything legally. Patricia has vandalized survey markers, blocked my easement, and repeatedly filed false complaints. I am not the problem here. Several people started nodding. The tide was shifting. Thomas stood up. "I move that we table this proposal indefinitely. The HOA does not have the funds for this kind of purchase, and it is not our role to settle what is essentially a personal dispute between two residents." The motion passed 4-1. Only Derek voted with Patricia. After the meeting, Patricia cornered me in the parking lot. "You have made an enemy of the wrong person," she said, her voice low and angry. "I will make your life miserable here. You will regret ever moving to this neighborhood." "Is that a threat?" I asked, my phone out and recording. She noticed the phone and stepped back. "It is a promise. This is not over." But she was wrong. It was close to being over. The next week, I received a call from Officer Davis. "We have been investigating some of the incidents at your property," he said. "The obstruction of the easement, specifically. We pulled traffic camera footage from the intersection near your street, and we caught the dump truck that delivered that dirt pile." "And?" I asked, hopeful. "And we tracked down the driver. He confirmed Patricia Henderson hired him, paid cash, and specifically told him to dump it across the easement. She told him it was her property and she was blocking a trespasser." "So, what happens now?" "We are charging her with illegal obstruction of a right-of-way. It is a misdemeanor, but given the cost you incurred to remove the obstruction and the clear intentional nature of the act, the DA thinks they can make it stick." Patricia was arrested the following Tuesday. The sight of a police car in her driveway, the brief walk to the cruiser in handcuffs, and the ride to the station was the talk of the neighborhood for days. She was released on her own recognizance that evening, but the damage to her reputation was done. Several residents called for her resignation from the HOA board. Thomas circulated a petition, and within 3 days, they had enough signatures to force a recall vote. Patricia fought it, of course. She sent out letters claiming she was being persecuted for standing up for community values. She insisted the charges against her were false, and that I had somehow manufactured evidence against her. But the dump truck driver testified, the traffic camera footage was clear, and the timeline matched perfectly with the appearance of the dirt pile. There was no credible defense. The recall vote was held at the next regular HOA meeting. The room was packed. Patricia gave an impassioned speech about her years of service to the community, all the improvements she had championed, and the sacrifices she had made. Then Thomas spoke. "Patricia has done good things for this neighborhood, but she has also abused her position. She has used HOA resources to pursue a personal vendetta. She has broken the law, and she has exposed the HOA to significant legal liability. I cannot support her continuing in leadership." The vote was not even close. Patricia lost 73-19. She stood up, grabbed her purse, and walked out without another word. I actually felt a small amount of sympathy for her in that moment. She had let her need for control destroy her standing in the community she claimed to love. The criminal case took another 2 months to wind through the system. Patricia ultimately pleaded no contest to obstruction charges. She was sentenced to 300 hours of community service, 2 years of probation, and ordered to pay restitution for the cost of removing the dirt. With Patricia off the board, the new HOA leadership was much more reasonable. Susan Martinez came back and was elected president. One of her first acts was to send me a letter formally acknowledging the easement and apologizing for the conflict. My workshop was completed in November. It was everything I had hoped for: a spacious facility with proper lifts, air compressors, and enough room to work on multiple projects. I started restoring a 1967 Mustang I had bought years ago and never had space to work on properly. The neighborhood gradually returned to normal. People stopped talking about the dispute. The easement became just another part of the landscape, a strip of land that happened to provide access to my property. I saw Patricia occasionally, usually when she was leaving for work or returning home. We never spoke. She would look away or pretend she did not see me. Her lawn was still immaculate, her house perfectly maintained, but there was a sadness to her that had not been there before. 6 months after everything was resolved, I was working in my shop when someone knocked on the door. It was Patricia. "I owe you an apology," she said without preamble. "What I did was wrong. I let my need to control everything get the better of me. I cost you money, time, and peace of mind. I am sorry." I studied her for a moment. She looked older, tired. "Why now?" I asked. "Therapy," she said with a rueful smile. "Part of my probation. The therapist helped me see that I was using the HOA to feel important, to have power over something. When you challenged that, I lost perspective completely. "I accept your apology," I said. "I never wanted to be enemies." "Neither did I, though I certainly acted like it." She glanced around my workshop. "This is impressive. You do good work." "Thank you." She left after that, and I went back to working on the Mustang. I never became friends with Patricia, but we reached a civil détente. She would occasionally wave when she saw me, and I would wave back. The easement remained, clearly marked and legally protected. I used it whenever I needed to, and no one ever complained again. The HOA focused on actual community issues like organizing neighborhood events and maintaining common areas, rather than fighting pointless battles over legal rights. Sometimes I think about those chaotic months, the stress and conflict that consumed so much energy. It taught me something important about standing up for your rights, even when it is difficult and uncomfortable. If I had backed down at the first sign of resistance from Patricia, I would have lost access to my property and abandoned my dreams for the workshop. But it also taught me about the danger of letting disputes become personal. Patricia was not a villain, just a person who had lost perspective. The real enemy was not her, but the mindset that values control over cooperation, rules over relationships. My workshop has become something of a neighborhood attraction. I host occasional open houses where people can see the restoration projects I am working on. Kids from the area come by to learn about classic cars, and I have started teaching basic mechanics to anyone interested. The Mustang restoration was featured in a local car magazine, which brought some attention and a few commission requests. I am not trying to build a big business, but restoring a couple of cars a year for other enthusiasts brings in some extra income and keeps me engaged in work I love. The easement that caused so much trouble is now just part of the routine. The loader comes and goes when needed, carrying materials for new projects or hauling away scrap. The ground has compacted into a solid path, marked by the tire tracks of vehicles that have passed through countless times. The property values in Meadowbrook Hills did not collapse, as Patricia had predicted. If anything, they increased slightly. My workshop added character to the neighborhood, proof that this was a place where people could pursue their passions. Thomas Chen stopped by one afternoon while I was working on a 1972 Chevelle. "I wanted to thank you," he said. "For what?" "For not backing down. Patricia needed someone to stand up to her, and you did. It was not easy and it was not pretty, but it needed to happen. The HOA is better now. We actually focus on helping the community instead of policing it." We talked for a while about cars and neighborhood matters. He mentioned that several other residents had approached the board about starting hobby businesses from their homes, something Patricia would have shut down immediately. Now the board was working on reasonable guidelines that would allow people to pursue small-scale entrepreneurship without creating problems for neighbors. "You started something good here," Thomas said as he was leaving. "Not just the workshop, but a shift in how we think about community rules. It is not about control. It is about helping people live their best lives while respecting each other." That perspective made all the conflict worthwhile. I had not set out to change the HOA or reform Patricia. I had just wanted to use my legal easement to build a workshop. But sometimes standing up for yourself creates ripples that go far beyond the original issue. The legal bills were substantial, though Richard had given me a significant discount as a professional courtesy. The restitution check from Patricia helped offset some of the costs, and the money I made from the first commission restoration job covered most of the rest. My attorney Richard retired the following year, and his daughter Elizabeth took over his practice. She still handles my legal work, though fortunately I have not needed much since the easement dispute resolved. She told me she uses my case as an example when teaching new associates about property rights and HOA law. 2 years after the initial incident, I received a letter from the county surveyor's office. They had been reviewing old easement records as part of a modernization project, and they wanted to confirm that the easement across Patricia's property was still in active use. I provided documentation and photos, and they updated their records with recent survey data. The surveyor who came out to verify the easement was the same Bob Williams who had originally marked it for me. "This is one of the cleaner easement situations I have seen," he told me. "Usually, these old easements fall into disuse and become disputed. The fact that you actively maintained and used it from the start helped preserve the right." "I had a crash course in easement law," I said wryly. "You handled it well." A lot of people would have given up when faced with that kind of pressure. Patricia moved away eventually. I heard she took a job in Phoenix and sold her house to a young couple with 2 small kids. They were friendly and unconcerned about the easement, which they had been properly informed about during the sale process. The new neighbors even benefited from the easement occasionally. When they needed a large swing set delivered to their backyard, I gave them permission to use the access route, and the delivery truck was able to bring it right to where they needed it. That small gesture of cooperation was everything the situation should have been from the start. Neighbors helping neighbors, working together instead of against each other. My workshop has been operating for 3 years now. I have completed restorations on 7 classic cars, each one a labor of love. The 1967 Mustang that started it all is still with me, not because I could not sell it, but because I cannot bear to let it go. It represents everything I worked for, fought for, and ultimately achieved. The easement remains clearly marked and regularly used. The pink flags were eventually replaced with permanent stakes, and the path is as familiar to me now as my own driveway. Every time I drive across it, I remember the battle it took to preserve that right, and I am grateful I did not give up. The HOA under new leadership has become a model for reasonable governance. They enforce rules that actually matter, like maintaining property appearance and ensuring safety, while giving residents freedom to use their property as they see fit within legal bounds. The neighborhood has become more vibrant, more diverse in its activities, and more welcoming to individual expression. I ran into Officer Davis at the coffee shop last month. He was retiring after 30 years on the force. "Your case was one of the more memorable ones," he told me. Not because of the legal complexity, but because of how it showed what happens when someone tries to use rules as weapons. You handled it with remarkable patience. "I wanted to throw in the towel more than once," I admitted, "but you did not. That takes character." Looking back, I realized the dispute was never really about the easement. It was about 2 different philosophies of community life. Patricia believed in rigid control, in rules enforced without exception, in conformity as the path to property values and peace. I believed in individual rights, in legal boundaries that protected freedom, in diversity making neighborhoods stronger rather than weaker. Both approaches have merit in the right context. Rules and standards do matter, but they cannot override fundamental legal rights or become tools of oppression against residents who are following the law. The workshop continues to thrive. I have taken on an apprentice, a teenager from the neighborhood named Marcus, who shows real talent for mechanical work. He comes by after school and on weekends, learning the craft of restoration. Watching him discover the satisfaction of bringing an old machine back to life reminds me why I fought so hard for this space. The easement that caused so much trouble has become almost invisible again, just another part of the landscape. Cars pass over it regularly without anyone thinking about the legal battles it once sparked. That is exactly as it should be. The best resolution to any conflict is one where the solution becomes so routine that people forget there was ever a problem. I still live in Meadowbrook Hills, still work in my shop, still use my easement. The neighborhood has accepted both me and the workshop as part of its character. The fear and resistance that Patricia embodied has faded, replaced by curiosity and appreciation. Last week, the HOA asked if I would be willing to host a community event at my workshop, a classic car show open to all residents. I agreed, and we are planning it for next month. It feels like a full circle moment, taking the space that was once so controversial and making it a center for community gathering. Patricia's name comes up occasionally in neighborhood conversations, usually in the context of cautionary tales about HOA overreach. I do not participate in those discussions. She made mistakes, she paid for them, and she moved on. That should be the end of it. The classic car show is scheduled for a Saturday in June. We are expecting over 50 vehicles from around the region, with awards for Best Restoration, Best Original Condition, and People's Choice. The proceeds will go to a local youth automotive program. I have invited Marcus to show the Chevelle he has been helping me restore. He is nervous but excited, proud of the work he has done. That pride, that sense of accomplishment, is what the workshop represents. It is a place where passion becomes skill, where dreams become reality, where people can create something meaningful with their own hands. The easement makes all of it possible. Without that legal right of access, none of this would exist. The workshop would be an abandoned dream, the restorations would be incomplete, Marcus would not have found his calling. That is the real story of the easement dispute. It was never about dirt and flags and legal documents. It was about protecting the space to live life on your own terms, to pursue your passions, to build something that matters. Patricia could not see that. She saw only rules being challenged, authority being questioned, order being disrupted. And in her determination to maintain control, she lost sight of what communities are really about. People living together, respecting differences, and finding ways to coexist that allow everyone to thrive. The workshop stands as a testament to a different philosophy. It proves that property rights matter, that legal protections serve important purposes, and that fighting for what is right can lead to outcomes that benefit everyone. I am not a hero for defending my easement. I am just a person who refused to be bullied into giving up something that was legally mine. But in doing so, I helped shift the culture of this community toward one that values individual rights alongside collective standards. The classic car show will bring hundreds of people to my property, all crossing that easement that was once so controversial. They will admire the cars, enjoy the community gathering, and probably never think about the legal battles that made it possible. That is exactly as it should be. The best victories are the ones that become invisible, woven so seamlessly into normal life that no one remembers there was ever a conflict. As I prepare for the show, cleaning the workshop and organizing the space, I think about the journey that brought me here. The early morning confrontation with Patricia, the police calls, the HOA meetings, the legal filings, the fence blocking the easement, the dump truck full of dirt, the arrest, the resolution. It was exhausting, stressful, and at times seemed endless. But it taught me valuable lessons about standing firm in the face of unreasonable opposition, about the importance of documentation and legal preparation, about the power of community support, and about the ultimate fairness of a system that protects established rights even against organized resistance. The sun rises over Meadowbrook Hills on the morning of the car show, casting long shadows across the easement that leads to my workshop. The grass along the path has grown thick and healthy, unmarked by the conflicts that once raged here. The flags are gone, replaced by the simple reality of a well-used right-of-way. Cars begin arriving early, classic machines from decades past, each one representing someone's passion and dedication. They drive across the easement without hesitation, following the path that I fought to preserve. The workshop fills with people, with conversation, with the shared appreciation of automotive history and craftsmanship. Patricia would probably hate this, I think, watching the crowd grow and the parking spread across multiple properties. Then again, maybe she would have come to appreciate it in time. People can change, can grow, can learn to see things differently. Her apology proved that, even if she ultimately decided to start fresh somewhere else. Thomas stops by mid-morning, bringing his family to see the show. "This is fantastic," he says, looking around at the gathered crowd. "You have created something special here." "It almost did not happen," I remind him, "but it did. That is what matters." He is right. What matters is not the conflict but the resolution, not the obstacles but the achievements they made possible. The workshop exists. The community has grown stronger. The easement serves its purpose, just as it was designed to do 30 years ago. As the day progresses and the show continues, I find myself standing at the edge of the easement, looking back toward the main road. The strip of land that caused so much trouble now serves as a literal and metaphorical path forward. It connects my property to the wider world, allows commerce and creativity to flow, and stands as a reminder that legal rights exist for important reasons. The judge who ordered Patricia to remove the fence was right. Recorded easements are not suggestions or preferences. They are legal guarantees, promises made by previous property owners that bind all future owners. They exist to prevent exactly the kind of landlocking and property devaluation that would have occurred if Patricia had succeeded in blocking my access. The show wraps up in the late afternoon. Marcus wins the People's Choice Award for the Chevelle, beaming with pride as he accepts the trophy. Cars begin departing, their engines rumbling as they head back across the easement one final time. People thank me for hosting, compliment the workshop, and express hope that I will do this again next year. When the last guest has left and the workshop is quiet again, I stand in the doorway looking out at the space I fought so hard to create. Every tool, every lift, every piece of equipment represents a choice to not give up, to defend what was rightfully mine, to stand firm against pressure that could have easily made me fold. The Mustang sits in the center of the workshop, gleaming under the lights, a rolling monument to perseverance. I walk over and run my hand along the fender, feeling the smooth paint that covers months of careful work. This car, this workshop, this entire enterprise exists because I knew my rights and refused to surrender them. The easement dispute is now just history, a story told occasionally but no longer a living conflict. The path remains, permanent and protected, serving the purpose it was always meant to serve. Patricia is gone, living her life in Phoenix, hopefully having learned from her mistakes. The HOA functions reasonably under new leadership. The neighborhood has moved on, and I have my workshop, my passion, my space to create. That is what mattered all along. Not winning the argument, not proving Patricia wrong, but preserving the ability to live my life according to my own vision within the bounds of law and neighborly respect. The easement will be here long after I am gone, recorded in county documents, marked on survey maps, protected by legal precedent. Some future owner of my property will use it just as I have, perhaps never knowing about the battle that once raged over this strip of land. That is the nature of property rights. They transcend individuals, serving purposes that extend across generations. As darkness falls and I lock up the workshop for the night, I take one last look at the easement stretching toward the main road. It is just land, just a legal right, just access to my property. But it is also more than that. It is proof that rights matter, that laws protect important interests, and that standing up to unreasonable opposition can lead to outcomes that benefit entire communities. The loader that started it all sits idle now, its work complete. The workshop is built, the materials are delivered, and the construction is finished. But the easement remains, ready for whatever future needs may arise, permanent and protected. A path that will endure long after the conflicts that once surrounded it have faded from memory. This is the story of a simple property right and the complex battle required to preserve it. It is a story about an HOA president who overstepped her authority, a homeowner who stood his ground, and a community that ultimately chose reason over rigidity. It is a story that played out in Riverside, California, but could have happened anywhere HOAs exist and property rights meet determined opposition. The ending is not dramatic. There is no final confrontation, no courtroom speech, no moment of triumph. There is only the quiet satisfaction of rights protected, work completed, and life lived according to one's own plan. Sometimes that is the best ending possible. Not victory over an enemy, but simply the freedom to do what you always had the legal right to do. The workshop lights go dark. The easement fades into the night shadows. Tomorrow will bring new projects, new challenges, new opportunities. But the foundation is secure, protected by law, defended through conflict, and now simply part of the landscape of my life. That is enough. That is everything.